I'm very excited that we have Ben Franta with us today. Ben is a senior research fellow in climate litigation at the Oxford Sustainable Law Program and the founding director of the Climate Litigation Lab at Oxford. He has a very illustrious career, starting off with a master's in archaeology at Oxford, continuing with a PhD in applied physics at Harvard, following with a separate PhD in history from Stanford, and then finishing it off with a law degree also from Stanford. He has been an advocate for climate action for many years and is now using the law to sue these murderous fossil fuel industry companies, which in my heart evokes nothing short of the greatest sympathy and admiration. So please join me in welcoming Ben Franta.
Thank you, Fabian. And it's great to see you all. I see my dear friend Yogi there in the front row. It's nice to see you and many others. Great. So I think we have about an hour or something to talk about climate litigation. I'm also happy to direct this conversation in whatever direction you're interested in. So maybe what we can do is I can present an overview in a short time, like 20 minutes or something. And then we can leave the bulk of the time for discussion. And that way, there's so much more to talk about, but that way we can talk about what's most interesting for you.
That sounds great, Ben. Yeah.
Great. So I'll share my slides. Share. Slides. Okay. Can you see this title slide?
I think it's not quite. I think if you go to full screen, we might see the whole. Yeah, or that works. Yeah.
Let's see. I think I can view full screen. How is that?
That's perfect.
Amazing. Great. So, yeah, it's great to be with you. I hope you've had an interesting conference. I'm sorry I couldn't join in person. It sounds really interesting there. And I hope this is of interest for your broader program. So I'm going to focus on how climate change litigation has grown over the past few years and the main areas of climate change litigation where it's heading into the future. We can also talk about the evidence that's used in these cases. There's a range of different kinds of evidence used, from historical research to scientific research, and so on. So, yeah. So let's get started here. As was mentioned, we have a research group at Oxford called the Climate Litigation Lab, and we conduct research to help inform these cases. So this is sort of our core focus. I think we're probably the only group in the world that focuses specifically on developing the evidentiary information used for cases, rather than sort of doing commentary or tracking cases, which is also really important. And there's some other academic groups that do that really well, but we focus on the evidence. And so we have a bunch of different subgroups and research themes going on. We quantify damages from climate change in particular places. So for example, in the US, the state of Vermont has a climate superfund law that was recently passed. It's the first law of its kind. And essentially the law says that the state treasurer of Vermont is to estimate how much economic damage climate change has caused in the state since 1995, I think, and then send the oil companies a bill. So this is an interesting proposition. It's basically seeking to obtain the cost recovery that some of these lawsuits are also seeking, but through a legislative avenue. So we're working to quantify damages from storms and flooding in Vermont attributable to climate change. It's one thing we're doing. We've also built a big library of greenwashing advertisements from carbon majors, because this is also a key aspect to these cases, these lawsuits, the greenwashing activity. And for people who are familiar with the history of climate politics and disinformation, this sort of greenwashing era where the oil companies are portraying themselves as clean energy leaders, that's been going on for over 25 years now. So it's quite a long time of this greenwashing era. And so we're trying to systematically collect these consumer-facing advertisements so that researchers can make use of that. And we actually have a library that has about 2,000 ads in it right now, and anyone, I think anyone here in the audience can obtain access because we can share it with any academics, any nonprofit groups, and so on for your research. So that's another thing we do. We have an artificial intelligence-based project where we're building a large language model-based tool for searching documents more quickly. Of course, this has kind of become a big area in AI in the last year or so. But what we've done, we call this tool Clara, the Climate Accountability Research Assistant. But what it does is it plugs into the UC San Francisco Industry Documents Library. And then you can ask questions to Clara in natural language form, and we have a specialized search architecture that we've built that is optimized for finding the right answer, basically, or right answers, relevant documents from the question, and not hallucinating, and bringing back accurate answers, and then linking to the source documents so that you can verify where that information comes from. So that's online right now. It's at clara-research.com. You can use it for free, test it out. And what's really exciting is we're constantly upgrading this. And so we're about to expand its capabilities so that right now it just has the fossil fuel industry documents in there. There's like maybe 1,400 documents in there. But very soon, like in the next week, we're going to be able to put in other document collections. So I'm thinking of you, Yogi, in particular here because of, there's lots of different kind of different industry document collections out there, from PFAS to benzene to tobacco, and we're going to be able to import those collections as well into this LLM-based tool, so you can search millions of documents much more quickly and easily than by using keyword searches. So that's another really exciting project we have going on. So all sorts of stuff. We also do some investigative archival research. We have an investigative journalist, Stella Lavantesi, on our team who's looking at how did oil companies adapt their own operations to climate change. And she's doing some really powerful work finding how the oil companies adapted to permafrost melting in the Arctic, because of course permafrost is one of the most sensitive systems, and there's a lot more warming in the high latitudes. So actually permafrost has been noticeably warming and melting since around the year 1990. And so the oil companies have been tracking this, adapting to this over time for the last 35 years or so, or at least a few decades. So that's really interesting too. That's a story that's not out there yet, but could be very important for litigation, and in particular litigation to do with high latitude issues. So anyway, that's kind of an overview of the work we're doing at Oxford. And yeah, so I want to give a little overview of what's going on in climate litigation. And I like to show this video, and if we won't show it now because of time, but if we just distribute the slides, you can see the link. But it's the governor of California and the attorney general of California announcing the state's lawsuit against the carbon majors in 2023. And it's really powerful. It describes the basis for the lawsuit, the remedies sought. Essentially the state of California is suing the top 5 oil companies, essentially, Exxon, Chevron, Shell, BP, ConocoPhillips, American Petroleum Institute, for deceiving the public about climate change for decades, and the resulting damages that have occurred because of that. And so the state is suing for past damages and also adaptation costs. So it becomes a very practical question to how much damage has climate change caused? What does adaptation cost? All of these economics related questions are really important for these lawsuits, especially now as some of them are approaching trial. So I encourage you to look into that. That's really interesting. And that's just one suit of many across the US. So we'll zoom out to the world in a bit, but right now, looking at the US, there are about 40 cases across the US of this kind. Some of the states have sued, some cities and counties have also sued the oil companies. And this is fundamentally for deceiving the public about climate change, both many, many decades ago by concealing their own knowledge about the problem, but also in an ongoing way through this greenwashing activity. And these cases are worth probably trillions of dollars in aggregate, because there have been adaptation cost studies done for just specific locations like San Francisco Bay that say sea level rise in San Francisco Bay is going to cost over $100 billion in property losses. Think about roads and buildings and houses and things like that. That's just from sea level rise in San Francisco Bay. So if we zoom out, it's a huge amount of money, and these are the biggest lawsuits monetarily ever to be filed, even bigger than the tobacco litigation, and that that's still the kind of the biggest resolved mass settlement so far, to my knowledge. That's about a little bit over $200 billion for the tobacco litigation. That was back in the late 90s that settlement was arrived at. And so, yeah, this is even bigger. So these are really interesting cases, and some of these cases are now approaching discovery, which is where the sides can get documents and things from each other. This is why we know so much about the tobacco industry, and we have millions of tobacco industry documents because of legal discovery. So we might see something similar with the oil companies and climate litigation. So that's a really interesting kind of area of climate litigation that's moving forward. But it's not just in the US, even though there's a lot of litigation in the US, but there's climate litigation all around the world. Not evenly distributed, as you can see from this map, but there's quite a bit in Europe, in Australia, emerging in Latin America, not a lot in Africa yet, but people are looking at that as well. So this is a global sort of phenomenon, driven by the lack of action to address climate change, the mounting damages caused by climate change, and growing evidence of corporate malfeasance to do with climate change, with companies concealing their own knowledge and making false and misleading statements to the public about the problem. Here's another way to look at it over time. This is the number of cases related to climate change filed per year. It goes all the way back to 1986 because some of these early cases mention climate change, or they talk a little bit about climate change, so they're included. But really, we see a big explosion over the last 10 years in climate litigation, and especially in this type of litigation targeting corporates directly and seeking damages. So that's kind of a new thing for this area of litigation. This is more like product liability law, and the types of lawyers involved are different. These are often for-profit plaintiff lawyers who do these cases for free, and if they win, they take 25%. So that means they're either going to work for 10 years and not really make any money, or they're going to work for 10 years and they're going to become rich. So they have a huge incentive to do these cases well and kind of go all in on this. And that's a different model than the traditional kind of environmental law model, often pursued by nonprofits, NGOs, and those cases are often against government for permitting decisions and things like that. So there's a fundamentally new flavor to the legal actions that are being brought now to do with climate change. Just to give a few examples of cases that are important, this is one of the first sort of corporate-oriented cases to be filed by the state of Massachusetts against ExxonMobil. It's a very surgical case. It's just against one company, Exxon. There's a lot of evidence of malfeasance from Exxon, kind of its historical role in being a ringleader in climate denial. And also, we have many internal documents from Exxon now from the 1970s and 80s that show that the company knew a lot about climate change and predicted a lot of the impacts that we're seeing today. But this case is just about misleading advertising, essentially. It uses a consumer protection law that's quite broad, basically says no unfair business practices, and that includes making statements to consumers that are technically true but are misleading because of the context. So for example, statements like, we do more carbon capture than any other company. This isn't an actual ad that Exxon regularly puts out. That might be technically true, but it could still be misleading because not many companies are doing significant carbon capture at all, of course. So this sort of law captures those statements and can hold those statements to be liable. So this is a really interesting case, and it was heavily litigated. Exxon countersued the Attorney General of Massachusetts, and that countersuit went all the way to the Supreme Court of Massachusetts. It was denied. It was thrown out. So this was intense, and it's still going on. And this case is, I think it's in discovery right now. So that's really interesting. And presumably they'll go to trial at some point. Here's just an example from Massachusetts complaint. It compares fossil fuel advertising to tobacco advertising. And so this is I think this is also psychologically interesting for us to reframe some of the communications we see about climate change. So if we look at this tobacco ad, which looks like it's maybe from I don't know, maybe the late 70s or something like that. There's nothing in this tobacco ad that is false. Technically false, right? It's just a statement. It says, considering all I'd heard, I decided to quit smoking or smoke True brand cigarettes. Okay, and it says low tar, low nicotine, think about it, right? But the overall impression given by this ad is that, if you want to be healthy, if you want to be fit, attractive, healthy, like this person in the ad, she cares about her health, she's playing tennis, and she's got a cigarette in her hand, then you should smoke these cigarettes, right? And, today we look at this ad and we might instinctively feel, okay, this is misleading because it's juxtaposing health with smoking, right? And so something very similar is going on with climate ads from fossil fuel companies, juxtaposing sustainability with fossil fuels and fossil fuel brands and things like that. And maybe we're not quite there yet psychologically in an instinctive level, but that's part of what these lawsuits are seeking to do, is to demonstrate actually these climate ads are also misleading, just like these tobacco ads were. So there's sort of some interesting kind of historical aspects to this too. This is another interesting set of cases. It's brought by a set of municipalities in Puerto Rico for a specific event, Hurricane Maria, which hit the island in 2017 and caused a huge amount of damages and death. And so the argument here is that climate change made Hurricane Maria intensify more quickly than it would have otherwise. And because of that, there was less time to prepare for the impact. There was less time to evacuate and so on. So this rapid intensification phenomenon with cyclones. This is sort of the causal link to climate change. And so this is a really interesting case. This is also still live. It just survived sort of a motion to dismiss from the oil companies. And a key thing here is that, you know, the defendants argued in this case that, whoa, all of this historical evidence is a long time ago, and it's before the statute of limitations, basically. So the statute of limitations means you have to file a lawsuit within a certain period of time after an unlawful act, or after learning about an unlawful act. And so there's sort of a preliminary judgment in this case, but the preliminary judgment is that doesn't matter, because that deceptive conduct is ongoing. It never ceased. So maybe back in the 90s, it was overt climate denial. Like climate change doesn't exist, or we don't know if it exists, or we need to do more research to prove it. We don't know if it's caused by fossil fuels. And today it's more like, don't worry about climate change because we're solving it. We're rolling out hydrogen. We're rolling out biofuels, carbon capture. But fundamentally, that pattern of deceptive conduct continues. So there is no statute of limitations that applies, because it's just one set of deceptive conduct. So that's, you know, one of the arguments for why these cases should go forward. And at least there was a magistrate judge in this case who agreed with that and allowed many of the claims to proceed recently. So this is also a very interesting set of cases. There's an interesting profile on one of the lead lawyers on this case. She's sort of an Aaron Brockovich character, I suppose you might say. And yeah, it's worth reading. It's interesting. Another example of a case based on a specific event, this one in Oregon for a heat dome. So this 2021 heat wave that hit Oregon and in particular Portland, Oregon, a major city. This event, based on attribution studies, was virtually impossible without climate change. And so here the causal link is quite strong. And in this suit, they're seeking $52 billion. So for the actual cost of the heat wave, $50 million, but $50 billion to prepare the county and the city for future heat waves, right? So you can kind of start to get a sense of how these costs add up and how big adaptation costs actually are. And so this is also an interesting case that's moving forward. Internationally, there are also some damages suits. This, I think we're waiting for some judgment from a German court currently. I think we'll get that in May. So here we have a lake, a glacially fed lake in Peru, and there is a town beneath it. And because of global warming, it's becoming more and more likely that there will be a what they call an outburst flood. So this lake will kind of flood out because of the melting glaciers and flood the town. And so this is suing a German power company called RWE, which is a heavily coal-fired power company, for adaptation costs. But just based on RWE's market share. So RWE is responsible for something like, I think it's 0.04% of global emissions. So they want 0.04% of adaptation costs. So this is kind of an interesting, like, symbolic. It's more of a precedential case, you know, in some sense. So this is also interesting. It's a transnational case. You have a Peruvian plaintiff or claimant, and then a German defendant. It's in German court. But the German court seemed to be taking this seriously. It wasn't dismissed. It wasn't thrown out. They're figuring out what to do with this particular case. And then there are another set of cases that are just as important as these damages cases, and they're trying to get courts to order fossil fuel companies to align with the Paris Agreement as a matter of law. So basically to force them to decarbonize. And so some of these cases are against fossil fuel companies. There's also cases like this against governments where they're asking the court to order the government to align with the Paris Agreement as a matter of law. So this kind of blew open in 2019 or so with this Urgenda case in the Netherlands. I'm sure you're really familiar with this. Some of you might know more about this case than I do. But basically, this was the first success in suing the government and under a domestic duty, sort of domestic laws, getting the government to, or ordering the government at least, to align with the Paris Agreement for some time. Now, Urgenda had some limitations because it wasn't aligning with the Paris Agreement for all time or till 2050. It was a shorter time frame, but that created the precedent that this idea was viable. And so a few years later, basically the same lawyers sued Shell under the same theory, arguing that Shell has a legal duty to decarbonize along the lines of the Paris Agreement under duty of care laws, and they brought in international human rights law in order to strengthen the argument as well. And the low court agreed, and the low court gave the claimants a victory, ordered Shell to decarbonize by like 50% by 2030, and that's on the way to the 2050 alignment with the Paris Agreement. So huge outcome. So that was appealed by Shell, and the appeals court recently sort of split the difference in a sense. So this is actually a really interesting outcome legally. The headline result was that the court gave the victory to Shell because it said this order to decarbonize is it's too specific. So we're not going to give Shell any particular order to decarbonize by a certain amount by a certain year. And the reasoning was that there is kind of no consensus about how to align with the Paris Agreement. Now, maybe that's wrong. Maybe that's not really an accurate kind of assessment of what the scientific consensus actually is. That's what the court sort of wrote or thought. So that's kind of interesting. But on the other hand, the court made a number of holdings that are victories for the claimants. The court held that there is a legal obligation to address climate change and to decarbonize by corporations, including fossil fuel companies. So the general principle is there as a matter of law, but precisely what the remedy is, the courts are still grappling with this. And so there was a part of the judgment that said or suggested that maybe a cleaner line is no new investment in fossil fuel development. So no new oil and gas fields, because that is clearly out of alignment with the Paris Agreement. And so maybe that's a cleaner thing to sue over, or a cleaner line. So that's actually something that I don't have a slide for it, but a new suit against a major bank in the Netherlands is seeking to address. So this is really interesting. This will probably be appealed again to the even higher court in the Netherlands. There's a similar case in Italy against Eni. It combines damages and this injunctive relief. There's another transnational case against a Swiss cement company, Holcim, by Indonesian islanders, basically seeking the same thing: damages for sea level rise and injunctive relief, ordering decarbonization. And this case might also seem a little random, but a lot of commerce goes through Switzerland. And so if this impacts Swiss law in terms of the decarbonization obligations of companies operating in Switzerland, that would have potentially a big effect on many companies going forward. And then we have international courts. So there was a recent case in the European Court of Human Rights to do with Switzerland. And essentially the court held that Switzerland was not doing enough to address climate change and with regard to its citizens in Switzerland, and that this was violating the European Convention on Human Rights. So this was a pretty interesting ruling as well. Switzerland then said it would not comply with the court order, and so it set up some tensions. So that's creating some maybe creative tension to move things forward. This is also a really interesting ruling. This International Tribunal for the Law of the Sea, something that you might not be familiar with. I wasn't until sort of this happened. But this is an international treaty to do with, maritime law and the law of the sea around the world. And I think it's the most widely participated in treaty in the world, potentially. It's almost all countries are part of it. And this tribunal gave an advisory opinion about climate change. An advisory opinion it's not an adversarial case. It's when some party comes to the court and says, can you just clarify what the law is around this issue? And so this was about climate change, and the tribunal said in their advisory opinion that greenhouse gases are marine pollutants because they affect marine life and this in the oceans. And that there is a legal obligation for all the parties in the treaty to address and minimize and avoid marine pollutants, including greenhouse gases. So the parties here are countries rather than corporations. So this could be interesting for litigation and focusing on governments going forward. And then the Inter-American Court of Human Rights is another regional human rights court like the European Court. And they're currently preparing their advisory opinion on climate change. It should be out fairly soon, the next few months, perhaps. And then the International Court of Justice, which is sort of the top international court, it's also preparing an advisory opinion. So there's a lot of law being developed right now about climate change, and that's all going to feed into climate litigation after that, and it might supercharge it. These are just some other case theories. There are so many different case theories about how to sue about climate change. Suing banks for financing fossil fuel development. There are some interesting cases suing oil companies for not adapting their own coastal infrastructure to climate change, which is really interesting. It has an environmental justice angle there, and there's so many of these coastal facilities, like think about refineries and import-export terminals that are potentially vulnerable to extreme storms and sea level rise and things like that, and they often hold a lot of toxic material there. So there's a danger to the local community if there's flooding there and release of toxics around. But adaptation costs there could be very high, especially when you multiply it by how many facilities there are around the world. They're a huge number. So this is also a potentially huge liability for the fossil fuel industry. I'm kind of skip some of this. There's been some huge victories in the UK lately, or at least this one was a pretty big victory. It basically holds that new projects, including fossil fuel projects, must take their Scope 3 emissions and their ultimate climate impacts into account when doing project approvals and things like that. So that's a systemic impact. There are more of these cases arguing constitutional rights or human rights. This is an example in the US where at the state level, there's been some success in arguing that there's a state constitutional right to a stable climate in Hawaii and in Montana so far. And then there's growing interest in exploring criminal liability for fossil fuel companies because it turns out corporations can engage in crimes too, not just individuals. A fun fact is that the biggest criminal fine ever levied in the US was against BP after the BP oil spill in the Gulf of Mexico back in whenever that was, I forget exactly, but yeah, so there's some precedence for sort of pursuing criminal law against these companies. And the argument here would be that actually these companies knew so much about climate change and they concealed so much that this is, implicating issues of reckless endangerment or even homicide or things like that. So that's an interesting argument that's being explored.
Ben, I think it would be good to slowly wrap up so we have enough time for questions.
Sounds great.
Awesome.
Thank you.
Cheers.
And then the last thing I'll mention here is just there's a growing area of litigation in plastics to do with plastics recycling fraud. It's argued that companies promoting recycling of plastics have known for decades that it would never be a viable large-scale solution to plastic pollution. And so there's some interesting cases about this, including the state of California also sued Exxon over this issue. And there's growing interest in, what are the effects of microplastics and of chemicals in plastics that leach into the environment and leach into our bodies, and what about that too? So that's an interesting area. And then this is a poll that discusses how popular climate litigation is. And I think this is really interesting because obviously there's been political capture on climate change for many decades that has prevented any meaningful, or let me say adequate legislative solutions from emerging. So the courts, that's one reason the courts are being turned to. And this is actually quite popular. This is in the US, so apologies for the US bias here. But even conservatives, so Republicans here, even most of them support making oil companies pay for climate damages. And, even it's sort of like even more people support making oil companies pay for climate damages than believe that climate change is real. So there's there's something interesting psychologically about making the big companies pay for lying, essentially. And it cuts across ideological divides often. And an example of this is the opioid litigation in the US was spearheaded by ultra-conservatives in the US, in Oklahoma, and then it spread, So this sort of corporate accountability angle can have broad appeal, and that's another interesting aspect to these cases. So I'll leave it there for now. That's sort of just like an overview of some things going on in climate litigation. There's a lot more to talk about in terms of the evidence, the historical evidence of concealment and deception and so on, and damages and all of that stuff. But I'll leave it there, and welcome any thoughts, discussion, questions you may have. So thank you.
Thank you very much.
Thank you very much, Ben, for this fantastic overview. There are a couple of questions here.
Yes, thank you so much. That was fascinating. I wanted to ask a pretty broad question. So in the last talk, the issue of climate litigation also came up, and there was a question about the role of climate litigation within the broader scope of the green transition and fighting against climate change. And the previous speaker said something about climate litigation potentially being more of a last resort, so kind of a sign that other systems have failed. And I was curious about your stance on this and how you see climate litigation within this broader scope.
Thank you. That's a really good question. I mean, I see as already at the last resort stage, because this problem of climate change was studied in depth from the 1970s until the end of the 80s. There was already a scientific consensus about many things about climate change by the end of the 80s. And that's when governments started to try to regulate and control CO2 emissions to avoid this problem. So, there was already an understanding in the 80s that to avoid the climate change we are seeing today, they needed to act then. because the energy system is big. It's infrastructure that lasts decades. So it takes a long time to replace that stuff and to move from one system to another. And so that was well understood in the late 70s and in the 80s with regard to climate change. So all the pieces were there, the knowledge was there. Of course, detection of climate change came in the 90s and so on. But, you know, things like carbon taxes were proposed in the late 80s. We're pretty much having the same policy discussions that we've been having since 1988. Even shareholder resolutions, you know, like the first one was filed in like 1991. It looks exactly the same as the ones filed today and met the same fate, you know. So all of those conversations are the same, and I see the courts as one of the only venues in which the fossil fuel companies don't have a total lockdown on the situation for them. You know, they're very good at locking down legislatures by controlling one party. Then if you control one party, you lock down the legislature. So I think the courts have a lot of promise. At least I hope they do. And that's one reason I kind of got into this space is I'm hopeful that the courts can do that. I don't think they're a panacea, but I think they can do some things, hopefully, that other institutions or systems can't. And I think another, just to add to this, is something the courts can do is discover information. So this is also really important from a justice perspective. Like, you know, this is all happening. I mean, we're already seeing impacts that are, you know, beyond human experience. And it's going to keep getting worse over the next, you know, generation or two. So it's important to understand how this happened. You know, how did society allow this to happen? And who knew about this and what decisions were made? And of course that feeds into accountability, but there's also historical accountability about not forgetting and about knowing what happened. So the courts have that power potentially as well to force companies to disclose, you know, what they knew and also what they're doing. You know, today when they're talking about doing carbon capture in their advertisements or in their investor calls, like, where are their business plans? Like, do they actually exist? And that's something the courts can pry open and actually force them to divulge that information.
Excellent. Thanks, Ben. I suggest we go a bit longer, and ideally we have short questions and possibly also a bit shorter answers so we can questions. Easy.
This is just relatedly, how does the law, or does it even, distinguish between individual accountability and then, like, for instance, in corporations and also in governments? Because if like the Swiss government is saying it's not going to comply, can individual politicians be held to account, and can within corporations, you know, if it's really obvious from documents that one person made a lot of decisions or a certain group of people do, what's the interaction there in the law?
Yeah, great question. The broad strokes are that it's hard to force governments to do things they don't want to do. And this has been a challenge in traditional environmental law for a long time because those suits are generally suing governments over like permitting decisions or things like that. And so governments are very good at like evading actually doing it. So an example is, 15 years ago, the Supreme Court of the US held that greenhouse gases are pollutants under the Clean Air Act, and therefore the EPA has a duty to regulate them. But EPA hasn't really done that since, because there are ways around that. And there's no police force really that will force, a government to comply. So that's always a challenge. I think it doesn't mean that those cases are not worthwhile. They can be very worthwhile and very impactful, of course. I mean, things like court-ordered desegregation and stuff, like these are really powerful for shifting societies. So, but suing corporations is a different ballgame, because if a corporation, like any private citizen, doesn't comply with a court order, then they're in contempt of court, and that's a crime. So, you know, the courts can seize assets. It can seize people. It can put people in jail, and you know, all of these things. So that's sort of a different ball game. Now, most of these cases are against the corporate entities rather than individuals, because you would, yeah, there's been some discussion of individual liability, but the corporations are kind of more suited to these cases, perhaps because, you know, the conduct here extends over many decades, and then the corporate form lives over that time period. So it's kind of considered to be the same entity over that time period.
Excellent, thanks. A very eager hand, Diego.
Yes. The principle of intergenerational equity, right? It's one thing that is emerging, but it goes in different ways, whether you are a continental or common law system. But is this something that can be done properly, and what do you know about it? Because do we get a group of trustees, and if so, who is going to be the trustee? Or do we get amicus curiae? But how can we just make sure that this shows up? Because it's certainly the way that we're going to be challenged by the future generation. We didn't do much. Why didn't we? And I think we need to have an answer for that, and we need to make it happen. So is this a possibility?
Yeah, I mean, this is a possibility. I think almost anything is possible, and we should be thinking that way, you know, to deal with this problem. And that's not unprecedented, because, you know, in the past, when we faced unprecedented problems, society came up with new solutions, right, to new problems, new technologies, and new, you know, the emergence of, you know, mega corporations in the Gilded Age in the 1800s that were more powerful than governments, and how to deal with that, right? And whole new sets of law were created to deal with that problem, right? So we have another problem now, and we should be thinking about what should be done. And some of the courts are starting to adopt this intergenerational equity concept. I think there's a case in Germany called the Neubauer case, where they explicitly adopted this sort of concept that the actions of the current generation should not make later generations worse off, or constrain their freedom. So we should not be reducing the options of future generations through our choices today. And that's one argument as to why we shouldn't delay decarbonization. We shouldn't say, well, we're not going to do it today because maybe in 30 years they'll do carbon capture, because that actually constrains that generation compared to if we took on that work today. But yeah, thank you. That's a great question.
There's also a beautiful recent Netflix documentary, I think, where children sued the federal government, particularly on that front. So a couple of more questions. I think where we are.
Yeah, thanks, Ben. I was interested in your sense of the advertising, misleading advertisements. We see these adverts on the TV and everywhere all the time. How important do you think these are to the oil companies, their overall strategy? And if you manage to knock them out, do you think it would really be a game changer?
I think it would be. And the reason is that these companies have been engaging in this for so long that it seems to be a core part of their strategy is to portray themselves as the solution, right? I mean, these companies are basically producing a product that is, you know, terracidal, you know, for lack of a better word. Like, I mean, this is one of the most destructive products ever sold, right? With the, you know, most destructive impacts and side effects ever sold. And these companies knew that, right? And so their credibility depends on being perceived as responsible corporate actors and being part of the solution. And this was the messaging line they came up with in around 1998. So they were, from 88 to 98, they were doing really overt climate denial. Like, we don't know if this is real. And that wasn't really working. So they shifted to, it's real and we're solving it. So don't worry about it. It's real, but we're solving it. And you need us. So they need a seat at the table. And this was their line. It still continues. And now there's some peer-reviewed research on the effects of these ads on consumers and their beliefs. And it's really interesting because it's some pretty small literature still, but it's emerging. But what it's finding is that even a single exposure to an ad, like let's say there's an Exxon ad that says advancing climate solutions, which is a common Exxon ad, that this measurably affects people's beliefs about Exxon. But when you give people the correct information, it partly neutralizes the effect of the ad, but not completely. This is really important because this indicates that just because there's accurate information out there, that doesn't mean that the misleading information doesn't matter, because it all kind of mixes together and it forms people's kind of views and assumptions about what's going on in the world. So I think it's probably quite important. And it's also the conduct that's ongoing. And I don't want to ramble, but I think it's really important that we address potentially false solutions. So if hydrogen is vaporware, if carbon capture is vaporware, then it's hugely destructive to spend time focusing on those things, because this is a time-sensitive problem. So, I'm hopeful that some of these cases can cut through the marketing and get to the truth of what's actually a viable solution to climate change.
Great. The Hague actually banned false advertisement.
That's what I would say.
Okay, Lisbeth, go ahead.
Yeah. I've been a deputy mayor to The Hague, and we started with seeing if in the advertisement space that local authorities are in charge of, if we could ban fossil fuel advertisements. It's been in place and it's been upheld by the first level of courts just a few weeks ago. So that's the beginning of some banning of some advertising.
That's amazing. That's a groundbreaking development.
Okay, far back, yeah.
Hi, thanks for thank you. I have a question that certain scientific communities may not agree on some findings. Particularly, I'm quite sensitive about the case of climate-induced conflicts, and what role do this unagreement between the scientific communities can lead to court rulings?
Thank you. I think I got part of your question, but maybe not the whole thing. If you could.
There is a disparity among the disagreement between the scientific communities regarding climate-induced conflicts, their different school of thought, and how effective is this disparity in impacts the court's rulings in these cases?
Yeah, this is disagreement in the scientific community about conflicts and role of climate change. Is that...
Climate-induced conflicts.
Yeah. I think this is a big issue. I think this gets to, for courts, this would raise questions of causation, right? This is a potentially complex reality, but it's not beyond, what can be argued, right? I think it's obviously it's different, but I'm thinking about the wildfires in LA. This is another example of a problem that is caused by multiple factors, right? So, but the climate change can make these things more likely to occur because they set the background conditions that can trigger these events and make them harder to sort of control. So, yeah, I think it's a really powerful point, and especially now as we're approaching various tipping points in the climate system. I think the first one is going to be the disappearance of all the tropical coral reefs in the world, right? And so, that's a major global impact, and of course, displacement of people and from extreme heat and conflicts and effects on agriculture. All these things are quite systemic and large, and any scientific research on those is quite relevant for for cases, including kind of the next generation of cases, because I think there'll probably be lawsuits about climate change for as long as there are entities to sue about climate change. So probably for some decades.
Excellent. I think we have one last very short question here in the front.
My question is, why is there an update right now in climate litigation, especially state courts, and why is this happening? Is there suddenly a change in the mandate, or you mentioned like political? Until now, it was captured these topics. So why is this happening?
Yeah, great question. So there's a simple answer to this or there's a complex answer too, I think. But the simple version is that in 2015, this is when the internal documents of Exxon were discovered by journalists that show that Exxon had secret research programs about climate change in the late 70s and the 80s, and concealed that, and had predicted a lot of the things about climate change, and had a lot of certainty about climate change, and that contradicted what the company said later to the public for many years. And so that was precisely the kind of evidence that was needed to go after Exxon and the other companies, by the same lawyers who went after tobacco, opioid industry, and so on. They knew what to do with that information. So that's like the surface level answer. I think there's a deeper answer, which is that the fossil fuel companies were very successful at shifting attention away from themselves for many years as not being the root of the problem, as everyone else is the problem. And that started to change around 2010, 2015 with social movements that began to put way more attention on the fossil fuel industry, like the divestment movement and so on. But a lot more attention was placed on the fossil fuel industry. And, this was part of the context in which those documents were discovered, and then these lawsuits started and so on.
I think that's a perfect place to end it. Thank you again, Ben.
Thank you all.